Hi everybody, this is Matthew Foster from the Artsy Fartsy Podcast Network, and today we're going to be releasing the very first episode of a new series called Art of Law, Law of Art, where I'll be interviewing Richard Alves, a patent attorney who specializes in intellectual property. Bear with us because it's the first show that we've ever done where we try to do it together in a studio environment, and we're new to that kind of thing. But the content was very strong, so we didn't want to hold it up. So, enjoy. This episode of Art of Law, Law of Art is brought to you by Avatar Computing. Avatar Computing is an IT company that specializes in a full spectrum of services, including web development, IT support, infrastructure design, and security. Look them up at www.avatarcomputing.com/commercial. Hi everybody, this is Matt Foster, and this is the first episode of Art of Law and the Laws of Art, which is a working title, so forgive me. But he is Richard Alves, and you are an attorney specializing in intellectual property.
That's right. That's right.
And the idea for this show, for people watching, because it's the first one, I figured I'd explain the premise, is that we are friends outside of work, and we also work together in other environments. Mm-hmm. And we often find ourselves talking about patents and property and copyright. And I always sit there and go, how can I be a creative guy that went to art school and know nothing about how to protect my work? And you always look back at me and go, yeah, I don't know how you could possibly do that. So I figured today for the first show, right, we'd really just do the 101 kind of what's a patent versus what's a copyright versus what's a trademark. So, I mean, which one makes the most sense to start with?
Well, I mean, I guess it really all depends upon what you're doing. I mean, as a creative guy and as an artist, it really could involve any number of intellectual property type laws. I would say that really intellectual property as a discipline is predominantly thought of, I guess, by the common man as patent law. That seems to be the area where most people gravitate to. But
is that like the most exciting one?
I guess it all depends. If you're kind of, I was going to say, if you're kind of a strange individual like myself, then yeah, it's exciting. But for most people, it's probably not all that exciting.
But I mean, in fairness, you do see patents like in the news a lot more than you would like copyright.
Yes, so. Exactly right. So you'd see any of the Apple lawsuits now, the Google suits; those are predominantly dominated by patent law.
Right.
So I would say that yes, patent is probably the one that most folks are familiar with, and then also within the broader topic of intellectual property law, there is trademark law, there's copyright law, and to a lesser extent, although equally important, I'm sure, is trade secret law. And the reason I say lesser extent is not because it's any less important for the individual that owns the trade secret, but simply because of the fact that patent law, copyright law, trademark law are all governed by federal law predominantly. Trade secret law is really a state law creature, so it really kind of varies a little bit from state to state.
So is trade secret law a completely different category? I mean, I realize you're saying it's regulated differently. Mm-hmm. Is it a sub-genre, if you will, of one of the other ones, or is it its totally own category?
It's really its own category. It's really something that it kind of derives from business torts, whereas patent law and copyright law are actually prescribed by the Constitution, Article 1, Section 8, Clause 8 of the Constitution. Trademark law also derives from the Constitution in the Commerce Clause, whereas trade secret law kind of came to being from various business torts and unfair competition law.
So if I live in Massachusetts, which I do, and as do you, it will have different trade secret laws than another state?
For the most part, there is a Uniform Trade Secret Act that kind of tries to even the playing field a little bit, but yes, I mean, essentially it could very well differ from Massachusetts to New Hampshire to Rhode Island to California, depending upon where you are.
Okay. Okay, so I know the ones from our conversations together, copyright seems to be for an artist, for someone making work and selling work, seems to be the main vehicle, if you will. Is that right? I mean,
yeah, I'd say that for an artist, really, copyright law is essential. I mean, copyright basically protects your expression of a particular idea. It protects what you basically put down on paper, whether it be a painting, whether it be a poem, whether it be a novel, or even to a lesser extent, maybe not so much for an artist, but copyright law still plays out in the IT world, where you would have copyright protection for a computer program.
Okay. So, in the world of copyright, and again, I'm harkening back a little bit to some of our previous conversations, and of course, people watching this don't know that, but it's kind of a setup for us to talk about. Is it also seems to be, in my opinion, and again, I'm not the lawyer, but it seems to be the most vague. Also, as far as like the patent ones, it seems like there's a very specific process where you apply for a patent, you do this, you do that, and there's a process that they have you go through. And when you and I talk about copyright law, there seems to be a lot more of a, well, if you made it and you, whatever, you could do any number of things to prove that it's copyright
Right.
without ever getting a judge involved or anything.
Basically, right. For the most part, you have copyright protection on whatever it is the minute that it is what's known as fixed in a tangible medium, whether that be pen to paper or brush to canvas, or whether that be somehow memorializing the code for a particular program. You get common law copyright protection at the moment that that happens.
And what is common law?
Well, basically what that means is that it's not governed by a particular statute.
Okay.
So it's something where you get that protection just as a matter of having fixed it in a tangible medium. Now, you do need to actually have a federal protection, or have federal protection, in order to bring suit in court. That is a prerequisite to bringing suit in court. You have to have some type of federal registration of your copyright.
Gotcha. So okay. So this is where it gets legit. Is we can talk about how I have the right to protect the work because I made it as soon as I made it, but I still have to, at some point, if I'm ever going to take action on that to defend myself or to attack somebody, I'm assuming,
Right, right.
I would have to have some kind of actual paperwork done to justify that. Is that
Pretty
right?
much, pretty much. You could potentially submit some type of cease and desist letter to somebody that was not accompanied by a federal registration. However, if you were to file suit in court, you would need to have that registration in order to bring suit.
Okay. And my general feeling would be most people don't have that, right?
I think that's probably a safe assumption.
Yeah,
That's a
okay.
safe assumption.
So, so I'm an artist, and I make paint. And again, I mean, I think what we're going to do today is just talk about the basics of each, which like copyright, I would say we're almost kind of like have well rounded that already. But for future shows, we can hone in on copyright, obviously, and there are steps though that me as a painter, which is real, right? There's probably a process that I should do to better document myself, I'm assuming. And in all honesty, this show will probably turn into the template for what I'm going to go do. You know what I mean?
Right.
But I can almost guarantee you, I mean, being a person who went to art school, has a career, not in the arts necessarily, but a career that revolves around creating things and developing things. And then also, I'm a gallery owner, so I have some understanding of copyright due to that. But in all honesty, I don't have a firm grasp on it, and it's certainly not something I'm actively doing on my own work.
Right.
So, and I would assume that that's fairly normal for most general working artists. I can imagine the guy that's very professional. He's been doing this for 20 years, and this is all he does to make a living. I'm sure that artist is probably more savvy on it, but I can imagine the part-timers definitely have no.
Yeah, I think that's probably an accurate observation, and really it is something where copyright law is, or copyrights in general they can be obtained on a relatively inexpensive basis, especially vis-a-vis some of the other forms of intellectual property. I mean, it could cost you tens of thousands, if not hundreds of $1,000s, depending upon how you're prosecuting a patent application in order to get that protection.
Wow.
Trademark law as well, or trademarks in general, they're less expensive by far than patents, but they're still, they can run into the hundreds of dollars in order to file an application with the United States Patent and Trademark Office.
Okay.
Part of the reason for that is because the patent protection process and the trademark protection process involve a substantive examination of the application by the USPTO. Copyright Office does not do that. You can get a copyright for relatively little in the way of expenditures. It is $35 to file an application, and it simply is a something where as long as you have all of the blocks checked off correctly and you have all of the information in there,
You get it.
and it meets some minimal criteria within the Library of Commerce, which Library of Congress, which actually runs the Copyright Office, then they will send out your registration certificate.
And are you set when you do that? And again, I know we're going to parse this more later, but $35, not to be cheap, that's per item that you're copywriting.
Right, right.
I couldn't say, hey, I have a whole series of paintings, I want to copyright them. It would be $35 per painting.
You know, interesting question, because really that all comes down to what it is that you're looking to protect. I mean,
The series or each.
exactly. Right?
Ah.
Are you protecting a single work, or are you protecting what is more of a compilation of works?
Gotcha.
So it really depends upon what you're looking to protect.
So you started talking about patents. Let's really parse out what's the difference. So a patent, my interpretation, which is probably wrong, okay, and I'm expecting it to be wrong, but my interpretation is that a patent is more for something that is a business thing that you're trying to protect from your competitors, versus a copyright, which is just something that you say, I made this, I want people to know that I made it.
Right.
Is that a fair way to say it?
It's a fair characterization, I think, yeah. I mean, basically what it is that like I said before, copyright protects your expression of a particular concept. A patent is protection that you get on really more of a tangible item.
Okay.
So you have whatever it might be. You have some better mousetrap that you've come up with, and you get the protection on that for a limited period of time. It's basically 20 years from the time that you file the patent application.
Okay.
And what you're doing is you have to fill out that application in such detail that it will allow anybody else that is normally skilled in that particular art to go out and make that themselves. So it's almost a grand bargain between the government and the inventor, where they'll give you a monopoly for 20 years ballpark, because it's going to take you a couple of years to actually have the application see its way through and for the registration to issue. But you'll have a monopoly on it for ballpark 20 years, and in exchange for that, everybody else, society as a whole, has the recipe for how to make whatever it is that you're making. And that's why they're willing to do
And
that.
they have to make a deal with you to utilize it.
Well, after the registration expires, then no, anybody can go in and make that. And that's you see it all the time with pharmaceuticals, for example, drugs. You get your generic drugs coming in ballpark, 17 years after the initial drug is
Right.
produced, and that's because at that point anybody can come in and manufacture that.
So with a patent, the protection, I mean, it seems like it's very, very granular. Is that and what I mean by that is, and I'm, you know me, I'm like on the tech side of things also. So they always have these filings, when you watch the tech blogs, that, oh my God, Apple filed a new patent for this thing. And a lot of times it's something that's this minor change, but they'll still file for a patent. Is that normal, or is that really to IT?
No, that's very normal.
Okay.
And the reason why is because patent law doesn't actually necessarily give you the right to make whatever it is that's patented. What it does is it prevents you, or it allows you to prevent anybody else from manufacturing that. So especially with tech type products, you'll get something where, well, I'll give you back up a little bit. I'll give you the classic law school example.
Okay.
You have a patent on a particular lock, say, for a door. Somebody else has a patent on the door itself. You actually, because you don't have the patent on the door, you might not be able to practice your invention. In other words, you might not be able to sell your lock for a door because you can't build the door. Or, another example would be the bar stool. You might have the patent on a four-legged bar stool. Somebody else might have it previously on a three-legged bar stool. You can't actually manufacture your four-legged bar stool because somebody else has the three-legged bar stool. So they'd be able to come in and say that you're infringing their patent. Therefore, you cannot
Because you
practice that.
involve the other three legs, you're infringing the patent?
Right.
So let me ask you a question about that then.
Okay.
Does a draft of how you would make, let's go back to the bar stool, right?
Okay.
Does a draft do you have to actually make the bar stool to patent it, or does the concept drawing of, hey, I think I drafted it up, here's the specs, I haven't actually made it yet though, does that, is it a requirement to have the real bar stool to make the patent?
It is. It is. You have to actually reduce the invention to practice before the application matures into a registration. And you'd mentioned, can I just sketch it out? I mean, the answer to that is yes. You have to sketch it out, but you also need to reduce it to practice before you get protection in it. You can't just come up with a concept and then never actually put it into practice and prevent somebody else for the next 20 years from
I guess
actually
that's
making
what I'm
it.
getting at,
Right,
yeah.
right.
So that might be a real telling difference between copyright and patent. Then is copyright, you could copyright just the draft of something, the idea of it, because like you were saying, you can copyright an idea.
Well, you copyright the expression of it. You copyright the expression of the idea.
Oh, so it's just the actual drawing that you're protecting.
Right,
That's it.
right. Although, if it's in a draft form, it doesn't have to be in its commercialized version. If it's in a draft form, you still have protection for it. Nobody's going to look at that draft manuscript and say, geez, that was never actually sold, or that was never actually put into final form, therefore you don't get copyright protection in it. You'll get protection with respect to copyright law the minute that expression is fixed in a tangible medium.
Okay, all right, that makes sense. All right.
Whereas patent is definitely different. You actually have to file the application. You have to sketch out exactly what it is that you're doing. You have to provide a great amount of detail so that anybody can take a look at that application in the future and know how to do what it is that you're getting protection for. And then you actually have to reduce it to practice as well. You can't kind of take your idea off the market for 20 years and prevent somebody else from using it.
And is this, I'm assuming this is where we get into, and again, we'll talk about this in future shows, but this is where you get into all this drama with you can't, patent a black box for a TV because it's a shape of all TVs, and you know what I mean? Like, there's definitely seems to be and again, I'm revolving around the tech scene, and this is really more about an artsy kind of thing, but I'm assuming that's where we get into all these weirdnesses where you got these large companies who are trying to protect the crap out of all their stuff, you know what I mean?
Right.
And they
right.
go down to such granularity that it's like, well, like the Apple thing.
Right.
We've tried to, they tried to patent the rectangle. You know what I mean? right? I mean, wasn't that one of the things?
Essentially, yeah. And you're right. I mean, it really is. You do go down to the granular level, like you're saying. And part of the reason why companies do that is because of the fact that, as we were talking about a couple of minutes ago, it doesn't guarantee you the right to actually practice your patented idea. It gives you the right to exclude others from doing it. So, I mean, again, I know we're kind of delving into the tech world as well, and maybe we shouldn't be doing that, but that's why you see so many patent cross-license agreements, because somebody could come up with a better way to do whatever it might be. And because of that, a company like Apple might say, hey, well, you know what, that's a great idea. I can't get to it, though, unless we have this cross-license agreement. And that's where it all comes in, and that's where the companies start working together, and that's why you will see some of the granularity of the patent process.
And that's why you always see that big list of patents on everything they do.
Right. Exactly.
Right, because of all the cross-licensing.
Exactly.
So what about trademarks? So trademarks is, and I often confuse the idea of copywriting with trademarking, because there's enough similarity there. I know that there's a difference, but explain that a little.
Actually, you'd be surprised, maybe not, at how many people do confuse copyright and trademark and patent for that matter. Having been a former attorney at the Patent and Trademark Office, the first year that I was down there, I was actually reading an article in the Washington Post. And they blatantly screwed up the distinction between copyright law and trademark law. And they were talking about the copyright protection on the Washington Redskins logo. Well, there wasn't any copyright protection that they were referring to. It was really trademark protection for the logo itself. So you're not alone when it comes to people confusing copyrights and trademarks and patents for that matter.
So trademark is specifically branding.
Trademark is essentially branding. What it is a trademark protects a single source, whether that source is known or anonymous. So if you come out and you have Apple, for example, they are protected in that name because of the fact that people can harken back to that particular source. They know what the source of the items might be.
Okay.
And that's really what it comes down to. You get trademark protection for the name, the logo, it could be anything. You have trademark protection in sounds. The
Oh, really?
NBC chime is a good example. Everybody knows the NBC chime. That's trademarked. You can have trademark protection in color. Pink fiberglass, Owens Corning. They have exclusive right to use the color pink when it comes to fiberglass insulation.
But so let me ask about this. So when you say they're trademarking the color, but they're trademarking the color in its use to identify a product.
Yes, exactly.
So it's not like they could make their trucks pink and no other truck can be pink.
Right, exactly. No, trademark protection is with respect to a particular source for very discrete goods or services. So they can't have pink as their trademark and, like you said, have a pink truck and then therefore have protection in the pink truck and sue anybody else for trademark infringement if they're...
And it doesn't stop them from having a pink truck, but
no,
they just can't
exactly.
stop
They can't stop
else.
anybody else from doing it. Exactly. Right. Exactly. But yeah, it could be any number of other items as well. It could be the particular configuration of say a restaurant. There was a famous case that involved the decor of a Mexican restaurant, and it really kind of fell into the trade dress category, which is a subset of trademark law. But it was so distinct that they had protection in that particular look and feel of the restaurant.
And people were mimicking it? I mean, did it turn it into an issue that they had to protect?
Well, that you raised a good question there, probably unknowingly. But, yes, the trademark owner kind of felt that they had to do that. And the reason why they felt that they had to do that is because one of the requirements of a trademark owner is that they police their mark. In other words, they have to go out and they have to make sure that nobody else is infringing their trademark, because if they don't do that, then that trademark falls into the public domain and it becomes generic. So some of the really what seem to be over-the-top trademark lawsuits that you might see, yeah, they're over the top, but they're really done for a reason. It's because the owner does not want to lose their rights to that mark.
Well, and by over the top, are they making it a spectacle so that it gets press so other people know they can't infringe on that trademark?
I think it's actually...
Or is that just a strategy I'm thinking of?
Yeah, I think actually what you might be looking at is the way that it plays out in the media, because, they'll file a cease and desist letter, and then the person that gets it will run to the newspaper or the TV station or whoever it might be and say, oh, look at this, somebody's trying to stop me from using whatever it might be, and it snowballs, and everybody says, well, nobody should have exclusive right to use whatever.
Right.
Well, that's not actually what's happening. They don't have the exclusive right to use that across the board. What you're seeing is somebody that is policing their trademark for a particular good or service,
right,
and they're actually required to do that. Otherwise, like I was saying before, they'll lose those rights. And trademarks, whereas we talked previously about patent law and how you get patent protection for 20 years from the date that you file the application. Copyright law as well. It's pretty long in duration. It's lifetime of the author plus 75 years for the most part.
That's copyright.
That's copyright.
Yeah.
So it lasts for a long time, but it's still limited in scope. Trademark is just the opposite. Trademark law or trademark protection lasts in perpetuity. As long as you're using that mark on a particular product or service, that trademark protection lasts forever. So what they do and why they go through such great lengths to protect that trademark is because they essentially have an asset that could be theirs in perpetuity. But then I mentioned a little bit in passing a few minutes ago, it might fall into the public domain. It might become generic, and that happens probably more often than you would think.
So trademark kind of turns into use it or lose it almost. I mean, if you were to think of it in layman's terms, it's not. It's only a right if you invest in the fact that you're trying to keep it a right.
Trademark is absolutely use it or lose it. In fact, actually, you cannot get trademark protection, until you are using it in commerce. And I've mentioned before that trademark law kind of derives from the Commerce Clause of the Constitution. You actually need to be using that mark in interstate commerce in order to have that trademark protection, at least at the federal level. So yes, it's very much a use it or lose it. And then it also depends upon how others might be using that mark as well. because that might impact whether or not you lose it. For example, at one point in time, escalator was a brand name for a particular moving staircase.
no
Aspirin
kidding.
was a trademark of the Bear Company. But because people have used it so generically, it
Yeah.
became generic and they lost protection to it.
The one I always think of is Xerox.
Xerox they've got an extremely aggressive trademark protection program where they go through great lengths to make sure that that doesn't happen to them, because it does. It happens more frequently than you would think.
Huh.
So it is, yes. It's very much use it or lose it.
Wow. That's cool. I mean, well, it's cool, but it's also like it opens up. I always feel like this way when we talk, like, you know, at the bar, at lunch, whatever. Oh, of course, right? That had to happen. Hopefully, it rings only twice.
It's a very important call, I'm sure.
I didn't think to unplug my Polycom. We're gonna ride this out. It'll
Okay,
work, so
that works for me.
we're too deep in now because we're nearly done. I think.
And then I'll grab a drink while we're talking.
Yeah. So this kind of is exactly why I felt like this would be a great way to discuss this, because everything you've brought up so far creates a new rabbit hole that I want to go down and discuss more. And granted, I think you and I both feed off interest in this in different ways. You know what I mean? But let's talk quickly about because it sounds like it's very specific about the trade secrets.
Okay.
Because we did mention that at the beginning of the show, but
Mhm.
I mean that is a separate category. But you said that that's state run,
Right.
and is that really? I mean, it seems to me that would be really just a business thing. Is that true, or?
Yeah, that's exclusively a business thing, I would say. And the classic example of trade secret protection is the recipe for Coke. That is not protected by patents. Conceivably, it could have been. It could have been something where they filed a patent application for it and got protection for it. But the decision that business made, that Coca-Cola made, is that rather than limit their protection to a finite period, 20 years after the filing of the application, trade secret law is something where you get that protection for as long as whatever it is that you're having protected remains a secret. So for the recipe for Coke, for example,
this screams like a disaster, but okay.
for the recipe for Coke, for example, that's a secret. They go through extreme pains to make sure that nobody gets that secret recipe.
Yeah.
And the upside of that is that they don't lose protection after 20 years. They're still protected in that particular intellectual asset.
Huh.
So had they decided to go down the patent road, they would have been limited to 20 years, and then anybody could have come in. Pepsi, Mountain Dew, or I guess Mountain Dew is a Pepsi product, but you get the point.
Yeah.
Anybody could have come in and seen the recipe and actually gone in and mimicked it.
Is the idea of these ways of protecting yourself all or nothing that way? Like if you choose trade secret, does that preclude you from also having a patent on it? It does.
It's a good question, and the answer is, as with so many things in law, yes or no. It all depends. Or yes and no, I should say. The reason being because some of them can coexist, others cannot. The example that you gave with trade secret and patent, they can't coexist because in order to get patent protection, you need to file the application and you actually essentially disclose that secret.
Oh,
so it's
makes
no
sense.
longer secret.
Gotcha.
But there are certain other areas where there can be some coexistence. They can overlap, and you could potentially have a kind of getting down into the minutia again, and I'm sure we'll talk about it more in the future, but with patent law. People usually think of what's known as a utility patent. It's broken down. You can have a utility patent, which is the basic invention itself, or there's also a design patent, which is kind of more for the configuration of it. And design patent and trademarks can overlap in a lot of ways. And there are some scenarios where you could have potentially design patent and trademark protection in a configuration or in a particular setup. But for the most part, it is something where you do need to really kind of plot out what it is that you want to protect and how you want to go about it. If the company had decided, if Coca-Cola had ever decided that they're going to seek patent protection on it, and then later kind of regretted that and said, oh, geez, no, I wish we could have done trade secret protection, that ship would have sailed, they would have lost that ability. So it is something where you do need to make a very smart decision early on in the process.
So is that and that's a strategy. I mean,
It is.
that's not, it's at one point it's a protection, but like you were saying with the trade secret thing, that becomes a business strategy after a while. Is that you don't want to be trapped into that legality. So
Right.
so it becomes a different kind of decision.
Oh, it absolutely becomes a business decision, and it's very much strategic in nature because of some of the the nuances involved. For example, I mentioned before that it could potentially run into the tens, if not hundreds of $1,000s to actually obtain patent protection. Trade secret is considerably less than that. I mean, all you have to do is really make sure that what you are doing is kind of kept secret. So for a business that might be, especially a fast-moving tech type business, if the whatever it is, the technology, the idea that you're seeking to get protection for is something that might be obsolete in, say, whatever, 2, 3, 4, 5 years, is it worth it to spend the money to get patent protection on that? Or is it something where you could conceivably protect that through the use of a trade secret?
Right, and that would make, especially for a quickly evolving industry, you
Exactly.
may not need it.
Exactly.
So,
Exactly.
cool. Well, that's a lot. I mean,
That is a lot.
This was a killer first episode. Let me tell you. No, but I mean, this is the reason that we thought this would be a good idea.
Yeah,
Is that-
no,
is that
absolutely.
it's such a fascinating and dense subject to parse out.
It is.
And I know that like what we just talked about here today was not overly about the arts necessarily, because we were kind of doing broad brushstrokes about
Right,
the whole
right.
thing. But it's great to understand the difference, because I would not be shocked if an artist or a designer and I just had a talk with Dennis Hart, who does one of the other shows with me, and he was very excited about this because he does design work, he does illustration work, and there's a lot of nuances between how those are his work versus who owns it, and so he was actually very interested in actually drafting me up some questions for you.
Excellent. And I'm sure we'll get into it more maybe in other shows, but you mentioned design work, and I guess it all depends upon what type of design you're talking about. But you're right. I mean, it can be any number of IP areas that intersect all at once. And with respect to the design, I mean, there was a case that was just recently decided at the Trademark Trial and Appeal Board, and then went on to the Federal Circuit, where fashion design, not necessarily home design or anything like that, but fashion design, somebody actually had trademark protection, believe it or not, in the red undersole of a shoe. And there was a question of whether or not they could prevent somebody else from using red on the shoe. But that's the design aspect of it. I mean, you're right. All of these things kind of play out in ways that you probably don't think about until you read something in the paper and say, wow, that's,
Right.
I never would have envisioned that playing out that way.
Yeah, I could see that all over the place. And granted, one of the future motives of the show is to present you with some of the interesting art world things that intentionally challenged copyright or
Right,
I
right.
mean, and I'm thinking of like especially things in photography and stuff where they intentionally did something that was seemingly copyright infringement, but then they did it in such an artistic way that they could weasel out of any kind of complication.
Right.
And I'd love to get your spin on that, or whether that's kitschy or if it's actually fascinating,
Absolutely.
or that kind of
Absolutely.
thing. So, all right, well this was a great first show.
I agree. It's a lot
Appreciate
of
you
fun.
doing it, yeah.
I appreciate you having me over.
And we will be back with another episode.